You're not hearing me? Anybody can't hear me? You doing okay? Good. Okay. Tim?
Okay. Well, I'll try and speak up a bit. Don't think that I'm yelling at you or anything like that. I am Tim. First of all, just to clarify one thing, I'm not an attorney for the Common Sense Alliance. That's my day job. I'm I'm becoming more and more attuned to land use legal issues as we move through these issues, but actually I'm a healthcare regulatory lawyer. I recognize many of you, but not everyone, and so what I wanted to do, if we could have the first slide, is really just make sure that we understand that we're talking about two different, distinct, but interrelated regulatory processes here. One's the update of our critical areas ordinance, and the other is an update of our shoreline master program. What we're doing first, and what I think is as it should be, is the review of our critical areas ordinance. This is a requirement under the Growth Management Act. The requirement is that we review and revise, if necessary, our regulatory provisions protecting critical areas. And so that's the process that we're in. The Shoreline Master Program is a slightly different thing. It is a process driven by the Department of Ecology. We could talk some more about the differences between those two. The main thing you need to understand is that the CAO process will be wrapped up first, and then we are in the process now of starting. I guess we're maybe well, I'm not sure how to characterize where we are in the Shoreline Master Program update, but it's not scheduled to be completed until into next year. We have had some, actually if we get the next slide, we'll kind of give you an idea where we are. Okay. In the critical areas ordinance, we're in the process of reviewing our current regulations based on what is known as best available science, which the county has over the last year engaged consultants to help it compile. If you're interested in what that is, it's a rather large, the synthesis of it is a rather large document that you can download and review on the county website, and I provided the site for it up here. My view is that having read this document, I still can't tell what proof there is that our current critical areas provisions are not working. And to me, that's the fundamental question when you're going to make additional regulatory changes, is to figure out what's wrong so you can figure out how most appropriately to fix it. And that's been disappointing in the process. There are a lot of recommendations that come out of the best available science document and some other documents that are available on the website recommending that we make certain changes, but what I find missing is what's wrong with any particular given provision in our current rules. And as I look around as a layperson, it looks to me as though the current provisions of our code certainly need a name change. We call them sensitive areas provisions now. They need to be called critical areas provisions. And there may be a few things that we could do better in them, but I still don't see exactly which ones are problematic. Okay, so that's where we are now, and I'll talk some more about that in a minute. We're also in the midst of the Shoreline Master Program update. The last things we had on that were community visioning summits. I don't know whether you attended the one on San Juan Island. I think they were interesting for a variety of reasons. Most important, I think that they indicate that we've got a ways to go into if we're going to try and come to a community consensus about what that vision is. The good news, I think, is we already had a vision, and once again, I'm not sure why it's necessary to change that vision. Because we set that up and folks have purchased property, they've developed, they've moved here or plan to move here based on the vision that we had. And so the question I have is, why do we need to change that? We're also in the process of updating our code enforcement provisions. This is something I think does need to occur because the current provisions don't make a lot of sense, and I'm not sure that they're actually giving us enforcement of the current rules. And so without enforcement of the current rules, it's kind of hard to tell whether we need to change those rules to something different. So at least going forward, we want to be assured that if we have rules, that those are going to be applied in an appropriate basis across the board. So that process has also started and is before the Planning Commission. There will be a number of key hearings before the Planning Commission and before the County Council coming up, and Common Sense Alliance will do everything we can to make sure you're aware of those hearings and what's coming up. If I could have the next slide. I want to talk about a few misperceptions that I think are dangerous. I won't get into how we got these misperceptions and where they're coming from, and I don't want to point any fingers. I just want to make sure folks are aware of some things that are out there and have been said that I think are misleading. The first is that only a few parcels will be affected by the critical areas revisions that are being proposed, and I just think that that's certainly not the case. I think most parcels will be affected, and all parcels at least will be at least indirectly affected by the impact of rules on other persons' parcels. So don't be confused about that. If you can look at when you see some of the maps that you'll see later, you'll get a better idea what that's about. Also, there's a perception that these revisions will affect only new development. And this particular perception applies both to the Shoreline Master Program update and to the Critical Areas Ordinance. But don't be confused. Both of these will have an impact on you, whether your house has been in place for 100 years or whether you're just planning to build it. And that is because there will be restrictions. That is to say, restrictions are proposed with regard to what you can do on your property within certain distances of critical areas, for example, the wetland. So even if your house has been in place for 100 years, you still won't be able to do certain things, as currently proposed anyway, within some distance. Whether that's 100 feet or 50 feet or 350 feet has yet to be decided. But there will still be an effect on what you can do on your property, regardless of when you did your building. Consequently, the assertion that you'll be able to keep on doing what you're doing today sort of depends on a couple things: what the final rules say and what you're doing today, perhaps. And so I don't think folks should be comfortable not paying attention to this process, because there are proposals that would affect things like gardens, orchards, grazing, and there's even proposals regarding use of areas by domestic animals. And I'll point out one of those in a moment. Okay, also there's a misperception that we have to do this or that, something specific, because of the Department of Ecology or the Growth Hearings Boards. The concern here is that we not negotiate against ourselves, that we come up with what we in San Juan County think is a sound regulatory position with respect to these things, that we take care to protect our critical areas in the way that we think is best, without concluding that we have to do whatever the Department of Ecology might want us to do, and without being concerned about the fact that we may need to defend our decisions at the Growth Board. We may, in fact, have to defend our decisions at the Growth Board, but if we've done our homework correctly, if we have the correct findings and have the correct reasons for what decisions we make, then we should be able to defend ourselves. And if we can't, okay. If that doesn't work, fine. If powers outside the county have an influence greater than our own, which some believe is the case, okay. But at least we as a community will have come up with the rules we think are appropriate and fair, and we'll have put those forth and attempted to defend those. The last thing is, don't be convinced that there's nothing we can do. And the fact that you've come out here this evening, I think, indicates that you may believe that there's something we can do, and I think there is. And it really amounts to asking questions and making sure that those in our leadership positions on the county council, on the planning commission, hear you and understand what your views are and what your position is. And I don't even really care. That doesn't sound right. I'm not concerned about which position you might have, because it's the combination of positions, it's the various views that we have that are going to get us to a place that has the best shot of being adopted and making it through the system. Okay, if I could have the next slide, I want to tell you what I think is wrong with the analysis we've done to date. This is my view. The first is that the current analysis fails to identify and quantify functions and values. And in fact, it's functions and values of critical areas that we are supposed to be protecting. It's not every acre or every square yard of critical area that has to be protected based on the regulations. What we're supposed to protect is the function, the value. We want those critical areas to continue doing what they're doing for us, helping us assure water quality, providing habitat, providing the type of rural community that we like to live in and that brought most of us to the islands at one time or another. Okay, so if we haven't identified and quantified those functions and values, it's going to be very difficult for us to first evaluate whether the regulations we have now are protecting those functions or not, because we can't quantify it. Further, there's a concept called no net loss. We're supposed to be preventing a net loss of those functions and values. If we haven't identified them specifically and quantified them specifically, I have to ask how we're going to tell if we have a net loss or not. So I think this is a piece of the analysis that hasn't been done very well to date and is going to put us in a position that may make it difficult to defend whatever it is we do. Okay, remember the last slide. All hope is not lost. I'm just pointing out places where I think we have some issues. The next is that it fails to consider, the analysis to date has not considered, at least to the extent I think it should, the effectiveness of the current rules. So we don't know what's not working. We just know what's been proposed to perhaps work better, or proposals for various best practice type provisions. In addition, we haven't evaluated the positive effect of our environmental programs that have been implemented in the county. We've done more than most other counties in the country through the Land Bank and the Preservation Trust, for example, at preservation and conservation. And even if we didn't have those, I know just from looking around the room and having visited people's properties that folks moved here with an eye to being thoughtful about the use and to keep things, well, like they are as much as possible. Last, I think that we have a problem that, if we could have the next slide, the current analysis doesn't seem to have focused sufficiently on three areas that we're supposed to be focusing on. One of those are the goals of our comprehensive plan. And our current comprehensive plan has two goals that I'll call to your attention. And this is important because this sort of sets the stage for where we start our analysis. This is a policy position that has been adopted by the county that we're supposed to make sure that we allow the use of property to the greatest extent we can, consistent with protecting critical areas. So if there's a choice, we're supposed to err on the side of protecting property. We're supposed to not adopt a rule that certainly protects, but also restricts the use of property more than it needs to. This only seems fair, first of all, but bear in mind that there's two parts to this. It's not just allow the use of property as much as we can. It's allow it to the greatest extent possible while protecting critical area functions and values. That's what we have to do. And there's no question we have to be protecting those functions and values. The question is going to be how we go about it, and going about it in a way that is sufficiently respectful of current property rights. This leads us to the third goal, that we're supposed to establish our critical areas requirements that are balanced and related to the impact. This is important because we want to be sure that whatever we're implementing is actually likely to work. That's very important because otherwise, why should we put additional restrictions on anybody if they're not likely to be effective at protection? So they need to be that. Also, there needs to be a balance in order to satisfy fundamental constitutional requirements. And we won't get into those details today, but that's something that the county has made a decision to do. If we could look at the next one, this is just, and we won't read this. It is available. This presentation will be on the CSA website. But these are the 14 goals of the Growth Management Act. And if we had more time, we could go through and talk about each one, but that would probably stretch our ability to keep people's attention. But it is very important to recognize that the Growth Management Act is not merely an environmental protection statute. It's a statute designed to look out for the health of where we live in all of the various aspects of where we live. And it's been broken down by the legislature into 14 goals. One of those goals adopts the goals of the Shoreline Management Act. So one of the 14 goals is the goals of the Shoreline Management Act. And I've summarized those on this slide. But basically, that's to encourage reasonable, orderly, thoughtful development of the shoreline. To maintain the natural character of the shoreline, while we're doing that, promoting public access through public property so that folks can have the ability to enjoy the shorelines that we're protecting. The one point I want to make here, just so that folks don't forget this when we move through the process, there may be some decisions that cause folks to scratch their head a little, because under the Shoreline Management Act, we're supposed to be focusing on statewide interest over local interests, and long-term goals over short-term, and long-term benefits over short-term benefits. Now, I can envision situations where those may be viewed as conflicting, but I would hope that in most cases they're not conflicting in the first place, that our local goals are consistent with statewide goals, and that the long-term is consistent with the short-term. So I don't think those are necessarily conflicting, but to the extent we have those decisions, the Act does tell us that. Okay. In the interest of not running out of time, I want to give that background because not everyone has been as immersed in this process as everyone else. So buffers are an issue we're going to talk about quite a bit as we move through these things. What's a buffer versus what's a setback? And we can talk about those to a greater or lesser extent, but the key difference is that a buffer governs activities. Oh, can we move to the next slide? Sorry. I moved it on my, anyway, it never matter. Buffers versus setbacks. The key is that a buffer zone governs not only where structures can be put, but would also govern what activities can take place in that zone. And so it's very important for us to think carefully through that process. Larger buffers are being proposed than the ones we have currently, up to 300 feet. And at least theoretically, there are some proposals that could go to 450 feet, but I think we're mostly talking about 300 feet, at least in connection with certain wetland areas. The best available science is interesting on buffers. An area that hasn't come before the council yet is in the marine buffer best available science, where there's a conclusion that 100 feet is probably adequate. And in fact, in the circumstances of San Juan County, perhaps 85 feet would be sufficient. Yet the proposal is, let's make it 150 feet just to be sure. So I question whether that's actually consistent with the science. There's also some other questions that folks should be asking about buffers. There's a proposal to reverse the long-standing interpretation that buffers don't cross roads. In other words, if there's a road running through what would be your buffer area, the buffer has to get bigger on the uphill side of the road. That's not consistent with the interpretation from the Department of Ecology, but it is in the best available science document that we're operating under right now. There are proposals to limit the activities that can go on in buffers. And as I mentioned some of those earlier, and in the interest of time, we'll move on, but it's very important to be focused on what those are so that if you are planning to have a garden that on your particular property needs to extend within the buffer distance from a wetland, you're able to get there. Can I have the next one, please? And we'll move through this pretty quickly. There are a few other issues that you need to be aware of. There's a focus on stream habitat, as opposed to habitat of particular individual species, a focus on stream habitat generally, and an effort to characterize a lot more areas of the county as streams than you might currently think are streams. I can tell you that based on my review of it, a lot of them look like roadside ditches. And so I really question some of that, whether we should have a buffer area set aside next to many of these ditches. The proposal is to have the entire shoreline of the county be considered a critical area, and limits that would attach to that. Let's move to, in the interest of time, the next slide, proposed non-conforming provisions. Oh, maybe I skipped that one. Let's move to the next one. There we go. There are also provisions that have passed through the Planning Commission and are now before the County Council that would change, that propose some new non-conforming provisions related to critical areas. Now, a non-conforming provision is what governs what happens if you've got a structure or a use, or I believe we should make clear an activity that is currently in place or currently being done in an area that would not be permitted under the new rules, and the circumstances under which you get to continue doing it even though it's not conforming with the current rules. I believe we're going to have a lot of structures within the county that will become non-conforming because of the proposals to expand the widths of buffers. You may have a house right now that's not within a buffer because it may have been a 100-foot buffer, but if that buffer gets extended to 200 feet, perhaps the house is now within the buffer, or part of the house is within the buffer, and would then become a non-conforming structure based upon where it is. You might have uses that became, well, we're not going to have time to get into the technical details about that, but I will raise a couple issues in a second. What I will tell you about the proposal that's before the council right now is that it has some improvement in it. The allowance to have 48 months to complete replacement of a destroyed structure as opposed to 24 months is certainly a favorable adjustment. The notion that you would have to abandon a use or activity for 48 months before it became considered abandoned is also good. There are new restrictions, however, that are in the proposal. And the two I want to focus on relate to repairs and replacement. Under the current rule, if you need to replace your home, you can replace the home entirely, provided it stays within the existing three-dimensional building envelope. And that's this third major bullet set down here. That's not what's proposed. Under the proposal, you would be able to replace or repair your house as long as the degree of nonconformity is not increased and no additional negative impacts to functions and values occur. You might say, how could replacing it the way it was have an additional impact? How could replacing it increase the degree of nonconformity? The answer is, I don't know. But as a matter of statutory construction, those words have to be given meaning. And so, in fact, there are two additional requirements that someone opposing your project to replace your house would be able to raise. They'd be able to argue that it increased the nonconformity in some way. I don't know what that would be. And they'd be able to argue that in some way it created an additional adverse impact. Now, I don't know if the argument would be that as soon as the house became rubble, the rubble was habitat. And so removing the rubble and rebuilding your house would have an impact on that habitat. I don't know if that's the argument or not. But I think these two things need to come out of here because the current rule that allows you to rebuild your house in the same place as it was, period, should be the rule. We need to also be focusing on activities as opposed to technical uses in land use planning lingo. That lingo talks about uses being residential, commercial, industrial, recreational. And I don't think there's much risk that those are going to be a problem. What likely is an issue is, can you continue to keep your horses where you kept them? Can you continue to rotate your grazing into an area that now is part of a buffer? Can you continue to have your garden in a place that now is part of a buffer? And those sorts of issues. So I think we need to be focusing on activities and make sure that the non-conforming provisions reach that. There will also be some tricky issues related to something called, whoa, man, that's Freudian. The last bullet should be SB 5451, not BS 5451. I apologize to anyone. I really did not do that on purpose. SB 5451 is a statute enacted in the last term that would allow the county to characterize non-conforming residential structures in the shoreline areas as conforming. Now that sounds good because you wouldn't have the non-conforming label on the property. But what comes with that is that anytime you wanted to, if you had to replace that structure that's now been called conforming, you would have to then comply with the current shoreline master program and the requirement of no net loss of functions and values. And so these are additional requirements that you don't have right now, even with the non-conforming label. So I have put up here, it's tricky. It's a tricky question that we don't have time to talk about right now, although we'd be happy to talk about with anyone about it later. I think we would be much better off focusing rather on the specific provisions of our non-conforming provisions rather than trying to avoid the non-conforming provisions altogether. Where was I? Okay. I'm supposed to be wrapping up just about now, but let me show you one more slide that I think is important. As we move through this process, first off, I think it's critical to recognize that there are strong emotional feelings on all sides of these issues. And I don't want to talk about sides of the community. I think there's always sides to an issue. And so in that respect, I think it's very important to recognize that whatever we come out of at the end of the day with respect to our critical areas and our shoreline master program, that we're still going to be neighbors. And we're still going to be a community and we're still going to be here. I hope that's the case. The real question we have is some very fundamental concepts, and that is, do we want to be more paternalistic, or do we want to continue to foster individual stewardship of the land and the property in the county? Do we want to really push for consistent enforcement of rules that we have? Or does it make sense to us to have more restrictions on everybody, good stewards and poor stewards alike? I think these are fundamental questions that flow through all of the decisions that the county council is going to be asked to make with respect to these rules. They function. How much confidence do we have in our neighbors? How will we treat our neighbors? And the fundamental question, why do people have to give up their hopes and dreams for their homes in the island? And that gets back to where I started. If there's a good reason, then most people are willing to suck it up, take one for the team, maybe not have things exactly as they would like to have them. But absent of showing that there's a very good reason for doing so, I have to wonder why it's fair to ask our neighbors to do that. So at this point, I think I'm just about right on time. I'd like to hand this off to Ed Kilduff.
Hold on.
No?
Let's have some questions if anyone
Oh,
has at this juncture.
that's true. I wasn't trying to dodge your questions. I have on occasion run long in order to avoid questions, but I'm not doing it tonight. Yes, sir.
You referred to the vision statement. I presume that's the vision statement that's 20 years old.
I was talking about the visioning. There were visioning meetings, visioning summits that were conducted with respect to the Shoreline Master Program update. And they happened on Orcas, San Juan, and on Lopez in the last few weeks.
So the reason I asked, that's irrelevant.
Oh, sorry. The question was about the vision statement that has been in place for a while now. And if you haven't seen it, I believe it's still available on the county's website.
We do have a vision statement. We partly this in the 90s, that it does make reference to rural character, but it equally makes reference to economic and social and other functions. Those seem to have gone by the wayside in all these current discussions.
The comment was that the vision statement does focus on retaining our rural character, but that the vision statement also includes a vision that includes a healthy economy and community as well. And I think that is true, and I couldn't have said that much better. Okay, yes?
Are there any members of the county council here tonight?
There are. Where'd they go? Oh, okay. And Rich Peterson is over here. I knew I'd seen them, I just didn't see where they went. Okay, well, we'll have some opportunity for additional questions if stuff has a chance to soak in, and as you're able to take in this additional information.
Good. Our next leader